Good morning.
Good morning, Your Honor. May it please the Court. My name is Jomarron, and I represent the appellates, the Gomez family. This is a case in which the trial court committed reversible error on two important issues. Number one, the trial court excluded rebuttal witnesses that went to the heart of the defense's theory, their principal defense. And number two, the court committed reversible error when it excluded a letter based on the unsworn statements of counsel and the court below.
Will you do me a favor and just speak up just a little bit? I'm having a little bit of a difficult time hearing you.
Of course, Your Honor.
Thank you.
Regarding the first issue, first I want to give the court a little bit of background on the facts. This is a case where a home exploded in Miami, Florida, and caused damages to the Gomez family's home about 150 feet away. Expert testimony was required in order to make that proof, to show how the shock waves or the blast waves went over from that exploded home all the way to the Gomez family home. During the trial, and the plaintiffs met their case in chief, made their prima facie case, and they proceeded to the defense's theory of the case. During the plaintiff's case in chief, not once were damages to any of the neighboring homes ever mentioned by the plaintiff's case in chief. There was no requirement to do so, according to Zaniletti, Young Chin, McFall, and Heberly. So the plaintiffs decided not to do that. The defense's theory of the case then, for the very first time, their expert testifies there was no damage to the neighboring home. And they specifically referenced the home directly next door to the exploded home. But the truth of the matter was, there was damage to that home. So immediately, the plaintiff sought to bring in rebuttal witness of the rebuttal testimony of the owner of that home, who would have testified, if you look at the proffered testimony, that she felt like her house was shaking up and coming out of the ground. And she specifically said it was like a boom, boom, boom. And then also our expert, who actually inspected that home and was going to opine directly that that explosion also caused damages to that home. So the expert for the defense's case said there was no damage. The court decided that it would be cumulative evidence because it would be cumulative and irrelevant. It's clearly not irrelevant because it goes to tend to prove or disprove the material issue in the case, which is how the explosion caused damages to the Gomez home. The whole issue was there was no path of destruction, but this house was in the path of destruction and it was damaged by it. Additionally,
Didn't your expert say there was no path of destruction?
With respect to fences, sidewalks, and driveways. See, the defense's theory of the case the entire time, their definition of path of destruction was these fences, sidewalks, and driveways.
That there was some sort of demarcation line. You could actually watch the damage as it went from the exploded house to your client's house.
Exactly. That's what the defense was telling the jury, that this needed to happen, almost kind of like a cartoon when you see a bomb and then you see the crack go all the way to the Gomez. And because that wasn't there, then the defense said, well, then it couldn't have caused damage to the Gomez home. Our expert's explanation was the reason you don't see that is because those materials, the fences, the sidewalks, and the driveways, are flexible. And they're not brittle like the roof tile and the floor tile. But when the court was explained this, the court didn't allow it. So let's just take a moment and think about what the jury was left with. When this evidence is not allowed, the jury just has evidence from the defense that this home, which was maybe 10 feet away from the exploded home, didn't have any damages. That was unrebutted.
But 150 feet away.
But yet 150 feet away it does have damage. How can that make any sense? No reasonable jury would find that way. Therefore, we sought rebuttal testimony to be able to explain, wait a second, that's wrong. Their expert is wrong. He didn't even inspect that home. How could he even give that opinion? That was brought out in cross.
So what about the court's decision or agreement that allowing these neighbors to come in and testify would create mini trials for each of these witnesses, each of whom had a pending claim against citizens for the same damage they claim occurred to their property, and that would be an undue waste of time. It would be unfairly prejudicial. It would be needlessly expensive, etc. What about that? Isn't that an abuse of discretion standard we measure this by?
There was 4 witnesses, the expert and the lay witnesses. So talking about the lay witness, they were going to factually attack the basis for the defense expert's theory. The defense expert said there's no damages there. The lay witnesses were going to say there weren't damages there before, but there were damages there after.
So clearly the implication is these neighbors were going to testify that the explosion caused damage to their home too, yes?
It wasn't going to be in the form of an opinion. It was going to be a factual basis.
But the clear implication of their testimony, from your point of view, would be you would argue in closing, these neighbors were also damaged by the same explosion. Yes?
Yes, Your Honor.
All right. So the trial court said, look, I'm not going to have a mini trial for each one of these neighbors who have pending claims against the citizens, the defendant in this case. It's a needless waste of time. It's going to be trials within a trial. I'm exercising my discretion. I'm not going to allow the rebuttal testimony. Given that our standard is an abuse of discretion, how can we reverse the trial court's determination in that regard?
Your Honor, the defense opened the door when the defense said that the neighboring homes had no damages. That was something that the defense did, not the plaintiffs. The plaintiffs didn't talk about the neighboring homes and avoided that issue. When the defense opened that door, it became an abuse of discretion not to allow rebuttal evidence. As the Zanoletti cases say in their litany in its progeny, the plaintiffs do not have to anticipate the theories of the defense. And that's what happened here. Once that door was open, the plaintiff had to have a right to be able to go and discredit or rebut that expert's testimony. And this is not...
You had the opportunity to cross-examine the expert, correct?
Yes, we did. But as the Heberling case says, that if we are trying not to get that evidence in, it would be poor tactics to open the door on something that we weren't trying to get in the first place. That's exactly what Heberling says.
But he had already opened the door, correct? The expert? The defense expert had already opened the door.
Yes. So we didn't bring it up in our case in chief. The plaintiffs didn't bring it up in the case in chief. We had the right to bring it up for the first time in rebuttal, which is exactly what we were trying to do. And now this isn't a lay opinion versus an expert opinion.
You had the opportunity to cross-examine citizens' expert who testified that there was no damage to the other homes.
We had that opportunity, and we exercised that opportunity. However, the expert remained steadfast that there was no damage to that neighboring home.
So is it a factual issue that you were trying to rebut, or is it an expert conclusion you were trying to rebut?
We were trying to rebut both. Now, importantly, it wasn't going to be lay opinion versus expert opinion. We weren't using the fact witness to rebut the expert. We wanted to use our expert to rebut the expert, and that's very important because we also sought the testimony of our expert, Mr. Brizuela, who was going to testify that he actually did inspect the neighboring homes, and that his report also, his opinion was that that explosion also caused damage to that neighboring home. The jury was left with evidence that this home, which is 10 feet away, wasn't damaged, and we weren't allowed to rebut it. That's an abuse of discretion as a matter of law, according to Zanoletti, Youngchin, McFall, and Heberling. Moving over to the next issue, which is the letter. That is also a commission of reversible error because the court simply relied on counsel's unsworn statement that that letter was sent by mistake to the Gomez family. This is specifically what this court ruled upon regarding the same trial judge in the Taverna case, where in the Taverna case, this trial judge also ruled on the unsworn statement of counsel as to the accurate description of the status of the case. And without record evidence, especially when counsel's objecting and couldn't present contrary evidence, that's an abuse of discretion and it's reversible error. This letter was relevant to the issues in the case. It was going to go to the citizens.
What issue was it relevant to?
It was
just to be clear, we're talking about the December 10th, 2012 letter from Walker to your client.
Yes, Your Honor. The letter was relevant for two important reasons. Number one, it went to the practices and procedures of citizens, which they had testified to extensively and argued about and talked about it in their opening statements. And additionally, went to an admission. The entire crux of the case was that citizens' defense was that this explosion didn't damage the Gomez family home. Yet this letter says to Mr. Gomez from citizens, the damages to your home were not caused by the owner of the home, but instead it was caused by third parties. They were referring to the tenants of that home who, as the court may know, was creating a hydroponics marijuana lab inside that home, which caused the explosion.
Right.
So it was directly to the issue of the case. So when the court...
Which was what?
Which is how the explosion could have caused damages to the exploded home.
So you wanted to use that letter as evidence of causation?
As evidence of causation and as evidence of the practices and procedures of citizens.
But the thrust of the letter was, regardless of what happened to you, we're not paying because it was a third party. Isn't that what the thrust of the letter was?
Yes, but it acknowledges that damages actually occurred, because then in the subsequent two other denial letters are saying you had no damages. So there was a contradiction there, and that contradiction was important. Now, the citizens maintained that this was just sent by error, this wasn't on purpose, it's a mistake. If you look at the record, we specifically said, well, Your Honor, then they should put the corporate representative on and let them tell the jury that it's a mistake. Right now, we have zero record evidence, even today.
Well, the way I understand it, Mr. Walker wrote this letter in his capacity as a liability adjuster for another insured, correct? Marcia Hernandez.
Yes, Your Honor.
Okay, so in denying the claim against Marcia or Hernandez, the liability claim, Mr. Walker wrote that it is our position that the damage to your property was as a result of actions of third parties and not as a result of the negligence of our insured. The inclusion of the term damage to your property, couldn't that mean whatever damage isn't the thrust of the letter is whatever damage your property may have suffered, it's not the liability of our insured?
Your Honor, I submit to the court that would have gone to the weight of the evidence, but the issue on appeal is whether or not it was properly excluded and whether or not that's an abuse of discretion. Because the court excluded it based solely on the fact that the counsel for the citizens made an unsworn statement that it was sent by mistake, and if you look at the record, she said, counsel, it was a mistake, right? Objection sustained. It was solely on that. Because of that issue, Taverna requires reversal, Sloan versus Sloan requires reversal, because trial courts are not allowed to take the unsworn statements of counsel and rely upon them as if they're evidence.
All right,
I reserve
I'll
the
allow
rest of my time for
you
rebuttal.
2 minutes for rebuttal
Thank
if
you,
you'd
Your
like, all right?
Good morning. May it please the court. It is a pleasure to appear for a second time this week before the court. Kara Rockenbach, and I represent citizens. This trial judge did what any good trial judge should do. She protected her jury. She protected her jury from confusion, misleading, and irrelevant testimony and evidence. First, the letter. This is really simple. There were multiple denial letters. Judge Scales, you asked the correct question. This was a liability third-party letter written by a third-party adjuster, Mr. Walker. Had nothing to do with this first-party property damage claim against my client. If the lawsuit was against Ms. Hernandez, if it was Mr. Gomez versus Ms. Hernandez, maybe there's some remote evidence or relevance of that letter. But what went into evidence in this trial was Exhibit 18, Plaintiff's Exhibit 18. It was the denial letter by my client to Mr. Gomez regarding his policy, no coverage for this loss.
So that was a confusion of the issues.
Absolutely, and the judge did the right thing. To preclude this evidence in this letter would have been misleading, and in fact, counsel, before the trial judge asked Judge Emas the exact same question you asked. Why did you want this? What issue was relevant to this case? And the trial counsel said, to show that Citizens is not a perfect insurance company. That goes to bad faith claims handling, and we know from the Florida Supreme Court, Perdita's son, my client's not subject to that. So the letter is an easy affirmance. The trial judge did not abuse her discretion in precluding that. With regard to the testimony of the rebuttal witnesses, this is going to require a very close look at the testimony that was presented to the jury. Because if you look at the initial brief in this case on page 9, it's citing to the record and saying that my expert, Mr. Hardy, testified that there was evidence of damage to other properties, and it cites to transcript page 920, 924, 963, 966. There's no direct quotation, interestingly, of what Mr. Hardy said on those pages. So if the court looks at those pages, what you will find is Mr. Hardy agreeing with what has already been presented to the jury through plaintiff's expert that there was no evidence of a path of destruction. Presumably, he's asked this question because Mr. Brizuela, plaintiff's expert, has already read Mr. Hardy's deposition prior to trial. Mr. Hardy's been consistent, no path of destruction. So Mr. Brizuela, in chronology for the trial, takes the stand first, and he says there's no path of destruction. To his credit, Mr. Brizuela candidly says, if there was a path of destruction, I don't think it would be a case in court. It would be evident that there was damage. Mr. Brizuela tells the jury first, there's no path of destruction. Yeah, no, there's no trees down, there's no this and that. He does say, he does testify on direct before my expert takes the stand that he was asked the questions, if Brizuela's calculations of, he had two theories, air and ground vibrations. And so he's asked, my experts asked the question, if the plaintiff's expert, Mr. Brizuela's calculations are accurate, then this roof of the house in between would have lifted off. Brizuela said the roof was damaged. Is that possible? And so we know from the record, Mr. Brizuela actually, during direct, testified about the house in between. The roof was lifted off. Mr. Hardy testifies, no, that's not possible.
Meaning it's not possible that the roof was lifted off
Right.
as a result of the explosion.
Correct, based on these calculations that Mr. Brizuela was offering to support his airwave and ground vibration opinions.
Meaning that it didn't happen, or that the waves wouldn't have been sufficient to cause it to happen?
Not sufficient to
Happen.
cause it. What's really key here is that my expert, he never inspected those homes in between. He didn't. Mr. Brizuela was hired by plaintiff's counsel because they filed suit in all of those cases, which resulted in verdicts in favor of my client. But Mr. Brizuela was the expert. He saw those houses and went inside of them. So he could have testified, and we would have had many trials inside of Mr. Gomez's trials about the damage of cracked tiles and cracked plaster. What this trial judge said is, no, we're not going to do that. And
Did your expert acknowledge that he did not visit the neighboring homes to inspect them?
I don't know the answer to that question, Your Honor.
Did he testify that there was no damage to the neighboring homes?
That there was no damage. What he testified to on those pages that are cited is, did you see any damage to the house behind? And the answer was this blast direction. Based on the blast direction, there couldn't be damage. What about vegetation? Well, I would have seen leaves blown out, and there was no debris. On cross-exam,
Is that not an implication that he visited the property?
Oh, no, and I don't believe that I know my counsel did not mislead this jury into believing that Mr. Hardy visited the properties. He didn't. So that would have been this incredible open Achilles heel on cross-exam. My expert would have said, oh, no, I didn't go into those properties. He didn't. He was hired to look at Mr. Gomez's property. He actually just walked the neighborhood, looked at photos from a report. So the judge said these rebuttal witnesses that citizens would then bring in their experts or some expert that would examine the homes, then we're going to have little mini trials within a mini trial or within this trial. It's not relevant. Even if these folks had damages, that's not Mr. Gomez's house. I don't see how that's relevant. The judge did the right thing. What this case was about was damage to Mr. Gomez's house. So Brizuela...
But surely it undercut the plaintiff's entire theory through his expert that if there were sound waves or air waves that caused damage to his property, the path of destruction would have been an unseen path of destruction.
Right, exactly.
Well, but here's the point.
Yeah.
If your expert left the jury with the impression, well, it couldn't have been sonic waves, it couldn't have been a ground of vibrations,
Right.
because if that was the plaintiff's theory, there would have been damage to the neighboring homes between the exploded home and the plaintiff's home,
Right.
and there was no damage to those homes. If that's what the jury was left with the impression of,
Right.
following your expert's testimony, then how is it not an abuse of discretion to prohibit the rebuttal witnesses from testifying?
Because Brizuela, plaintiff's expert, had already testified that there was no path of destruction. Would he
No
then...
visible path of destruction.
Right. Would
Well,
he-
there's a difference, though. Their theory wasn't visible path. Their theory was invisible path, or sonic airwaves, ground waves, yes?
But then he would have gone into each of these homes and testified what he saw about in the interior of these homes, behind the house, in between the
Well,
houses.
he might have. Certainly
If
that
she-
could have been a strategy.
That was what they were wanting to do.
But maybe they didn't want to subject their other clients in the other cases to being examined in the course
Right.
of this trial,
And
or
then
create the mini-trial.
Absolutely create the mini trials. And that's what they were trying to do by bootstrapping the three lay witnesses.
But you still haven't answered my question.
Okay, I'm
Which
sorry.
was, if their characterization of the impression left with the jury is a fair one, which is that as a result of your expert's testimony, you essentially eviscerated their theory, which was not that there was a visible path of destruction, but there was an invisible or an unseen path of destruction by airwaves or ground vibration, and that since there was no damage to the neighbors' homes in between the exploded home and the plaintiff's home, their theory could not be proven. If that's what the jury was left with the impression of, how can it not be an abuse of discretion to prohibit the rebuttal?
It would have been cumulative testimony based on what Brizuela had already testified to. There was nothing new that Mr. Hardy came out with. This was not new. In fact,
Except he said there was no damage to the homes in between.
and his testimony was really specific about, and I have it right here, about the trees, the sidewalk, and the street were undamaged. That was his opinion.
Everybody agrees to that, though.
Everybody agrees to
That's the
that,
path of
right. That's the path of destruction.
that
there's-
nobody is adopting as a theory.
Correct.
Right.
So, in addition to it being cumulative, that both of the experts agree that there's no path of destruction, if the judge had let in this testimony about the inside of these interior homes, it's clearly misleading and confusing to the jury that which homes are we trying? And all this plaintiff had to prove was damage to his home caused by the marijuana grow house explosion. What we argued and presented was, no, there was paint in the cracks of your exterior home, and you painted the home before the explosion. They were claiming those cracks were caused by the marijuana grow house explosion. Our expert goes, no, the paint was inside the cracks, and you painted it in 2006, 2011, explosions 2012. There wouldn't be paint inside those cracks if the explosion caused the cracks. So this judge did the right thing, did not rule in any fanciful, unreasonable, arbitrary way in abusing her discretion by making sure her jury was protected by the evidence solely relevant to this house and not creating this mini trial within a trial or misleading the jury with a letter that had nothing to do with a first-party property damage claim. We ask that this court affirm the jury's verdict.
Thank you very much.
Thank you, Your Honor.
2 minutes for rebuttal.
Thank you, Your Honor. On the issue of the rebuttal witnesses, Mr. Hardy, the defense expert, spent quite a bit of time on this, and I refer to the court to pages of the transcript 920 through 924, and just a couple of issues. He was asked, what kind of damage would it have done to that house behind the exploded home? It would have had to cause structural damage to that home. Okay, do you see that kind of damage in that home that you would expect to see if the blast were that big? There's no damage to this home, referring to the next door home.
Is he looking at a picture? Is he looking at a report?
He's looking at a picture, and actually the picture is attached to the appellee's answer brief. And it's the home right behind the exploded home in the direction of the Gomez home. So he's looking at that, and he's telling the jury that there's no damage to this home. This is something the plaintiff never, ever testified, never even got into. Now, the answer brief in page 14, the argument regarding the rebuttal witnesses, their argument is that cumulative is only because both experts agreed on the no path of destruction. But regarding being damages to the neighboring home versus no damages to the neighboring home, if you look at the entries, it's effectively a concession to that point by the appellee that wasn't discussed in the plaintiff's case in chief. The only reference to it in the answer brief is pages 489 and 490 of the record on appeal, and Mr. Brizuela makes no mention whatsoever of any damages to the neighboring homes because it never happened. I submit to the court there's zero record evidence of damage to the neighboring home. In fact, if you look at page 9 through, I believe, 19 of the transcript, there's a whole argument with the trial court by counsel talking about how we weren't going to bring it up until rebuttal. We put the court on notice, and we put the defense on notice that we were planning on bringing it up on rebuttal if the defense got into it. Then the defense went ahead and opened the door.
When did you put the defense on notice? Before the trial began?
Before the trial began, there was a motion in limine, and we were talking about whether or not the litigants were going to be able to talk about damages to the neighboring homes because we were worried about the mini-trial issue. But and what I said, I was the trial attorney, what I said is, if they open the door to talk about the neighboring homes, well then absolutely we're going to have to go in and talk about the neighbors. It's up to you, basically. And they did it. And I submit to the court right here on the transcript, page 920 to 924. Mark Hardy went even further than that. He said that home had to have structural damage. The roof had to be peeled off. If you look at the following page on 921, he said the roof had to be peeled off. This is absolutely an abuse of discretion. It's absolutely reversible error.
So what would you ask us to do?
I would ask the court to reverse and remand. Thank
Very
you
good.
very much.
Thank you both very much.